Good morning, everybody, and welcome. I'm Grant Loomis. Thank you for joining us. I'm Vice President of Government Affairs with the Buffalo-Niagara Partnership, and we truly appreciate your time this morning. We are here to discuss the New York HERO Act. This bill adds some major requirements onto employers, so it is important that employers learn what these requirements are and how they will affect your workplace. The bill requires employers to follow airborne infectious disease prevention standards established by New York State, and also gives employees the right to create safety committees in your workplace. On June 24th, the partnership and Barclay Damon hosted a webinar to explain the HERO Act and what it means for employers. That webinar is available on our blog. If you are not familiar with what the HERO Act is, please do utilize that resource. Since our last webisode, the State Department of Labor released its detailed HERO Act regulations. So we now know what exactly is required of employers. The purpose of today's event is to walk you through those standards and learn how you should be implementing them in your workplace. As I mentioned, the HERO Act also allows employees to create workplace safety committees. That section of the act does not go into full effect until November, and the state has not yet released the guidance pertaining to that regulation. The partnership will keep you informed this fall on what you need to know about workplace safety committees when we know more. Our government affairs team has played a very active role all year on the HERO Act. Our team was vocal about making amendments to the act as it was being debated in the legislature. Once it passed, there was a possibility that workplaces would have to follow these new protocols at all times, even outside of a public health emergency. However, the BNP urged the Department of Labor to only require these protocols during a declared public health emergency. We are very pleased that the state's final regulations match that important ask. Still, every workplace will need to have a disease prevention plan in place so that you are prepared in the event of another public health emergency related to airborne infectious disease. Even though the HERO Act is much less burdensome than it could have been, it still creates important obligations for all employers to know and understand. To help with just that this morning, we have partnered with Goldberg Segalla. We are joined today by Kristen Klein-Wheaton and Christopher Moggins from their team. Kristen is a partner at Goldberg Segalla and works on employment and labor issues, civil rights and discrimination claims, and commercial disputes. Christopher is an associate at Goldberg Segalla and concentrates on commercial litigation and employment and labor law. We are so glad they're here with us today and really appreciate their time and expertise. Their presentation is very comprehensive, so I venture it will address the vast majority of your questions. However, our audience is welcome to submit questions through the Q&A feature, and we will get to as many as we can toward the end of the program. And with that, it's my pleasure to turn things over to Kristen.
Thank you very much, Grant, and thank you for the opportunity to present on this very important topic. A little bit more about our firm. We do have 20 offices in 10 states. We have many practice groups, including employment and labor, workers' compensation, toxic tort, and general defense. I spend most of my day-to-day work counseling employers on compliance issues relating to the employment laws, including personnel and staffing decisions, as well as union negotiations and representing them in courts. And with that, we'll get started. Just a little bit of a disclaimer, nothing that's said in this presentation should be construed as legal advice. We're attempting to present you with the framework and the guidelines surrounding the HERO Act and the amendments, but certainly if you have a specific situation unique to you, we recommend that you consult with a qualified attorney for the legal advice. Now, to go through the agenda, which Grant touched on in the introduction, we're going to speak about the key enactment and deadline dates, the overview of the Airborne Infectious Disease Prevention Standard, an overview of the Model Airborne Infectious Disease Exposure Prevention Plan that's required, a discussion of industry-specific prevention plans, commonly asked questions. We're going to include a compliance checklist and then follow up with our question and answer session. So just a little bit of a recap of how we got to where we are here. Again, we don't want to be repetitive of the prior webisode, but just to remind people, as they may recall, on May 5th, 2021, the governor signed a bill that adopted the New York HERO Act. It created New York Labor Law 218B, which included a requirement for employers to adopt an airborne infectious disease plan. It also created New York Labor Law 27D, which required employers to permit the creation of joint employer and employee workplace safety committees, which was a new requirement. As Grant mentioned, those committees, there hasn't been additional guidance released on those committees, but that section of the act does take effect on November 1st. In the memorandum signed by the governor on May 5th, 2021, he indicated there was an agreement by the legislature to make technical changes to the bill. Then on June 11th, the technical amendments were released. And on June 14th, as you may recall, the governor announced that many of the COVID-19 restrictions were being lifted across the state because there was a 70% vaccination rate for those 18 and older. So on July 6, 2021, the Department of Labor released the Airborne Infectious Disease Prevention Standard, the Model Airborne Infectious Disease Exposure Prevention Plan, and industry-specific templates. So these were items that we were waiting for after the HERO Act was actually implemented, which were released on July 6th. So employers, it had been determined that employers would have 30 days to adopt the plans after the model plans were released. So doing the math, employers are required to have these plans in place by August 5th, 2021, to adopt a plan within the workplace. Again, you have 30 days after you adopt the plan to distribute it to your employees. So we suggest probably much of the legwork has been done on this already. If you had followed the New York Forward during the pandemic and had reopening plans, probably some of the same topics are covered in those plans as well. But it does need to match the new regulations, and you do need to distribute it to your employees. And now I'll turn it over to Chris.
Thanks, Kristen. So as Kristen mentioned, New York Labor Law 218B, that's the law that was enacted that creates these requirements, and the standard that was released in the plan, the plan that was released looks a lot like it. It just, so that's the statute, and they basically tried to turn it into a digestible format for employers to review. But if you've looked at the actual statute and you've compared it to the standard, it's pretty similar in its content. So it has three different sections: the standard, general provisions, exposure prevention plan, and then exposure controls. And when we get to the exposure controls part, as Kristen mentioned, you'll see a lot of familiarity with what was in New York Forward and what you've, as employers in New York, have already been doing during the pandemic. All right, so general provisions, who is covered? Employers with work sites in New York State. Sounds easy enough. So what is a work site? Work sites have a little bit of a modified definition through the amendment, but it includes a lot of different things. It's basically any physical space, which could be a vehicle that the employer controls, but it doesn't mean it's every single space that an employee works in. So for example, if you're sitting at home right now listening to this webisode, it's unlikely that your employer is controlling that space unless you're a part of some sort of package deal where the employer is providing for your residents, but they don't have control over that space. So that's not going to be a work site. But conceivably, there is potentially a shift in how businesses will operate moving forward. The concept of shared workspaces would be something that's considered a work site. So for example, what I mean by that is an employer that says, we're not going to have a traditional workspace, but we're going to have a workspace that you can come and go as you please, and it's just a space with resources and an ability to use that location. That would be something that the workplace, the employer controls, so that's going to count. Vehicles could possibly be falling within that definition. It's going to depend. If you work in an office and you drive to work every day and you have a 15-minute commute, that's not a place where you're actually doing work. And I know someone out there saying, well, I'm on the phone and I'm talking to someone when I'm going to work, so I'm technically working in that space. I don't think that's what it means. Perhaps there'll be future guidance that provides more clarity on that. but that is probably not going to fall within what a work site is under this definition. The other big piece, as Grant mentioned, is that this plan is only in place, and I guess sort of in effect, when there is an infectious disease that's been declared by the Department of Health. They made clear when they released this standard in this plan that there is no current designation for COVID-19, whether or not there is a designation in the future, if the numbers keep going up or there's another wave, will remain to be seen. But that's why it was so important when Kristen was talking about the timeline. Governor Cuomo lifted the restrictions right around the time this plan came out. I think there was some confusion over whether or not this law, this statute was supposed to be related to COVID-19. I don't think so. Based on the timing, I think they were just trying to make sure employers and the government aren't caught flat-footed if there is a future pandemic. So we'll see if it receives a designation at any point in the future. Hopefully not. Otherwise, it's conceivably not going to be in place until another infectious disease down the road. So who is and who is not covered? So if you're a public sector employer, this law does not cover you. So if you work for a town, a city, a village, a county, this is not the law for you. There was a similar law that was passed for public sector employers in fall 2020. That's not exactly the same, but it requires certain things along the same lines as the New York HERO Act. That's the law that's for you to review. This law, also this New York HERO Act, does specifically state a few things which are not unusual at all. The first is, it says if you're an employer that's covered by some other OSHA standard, you got to follow that too. So you're going to put this plan in place, you're going to follow the standard, but it's not to be viewed in a vacuum. And that sort of falls into the next point where it says, compliance with this standard does not relieve employers from complying with any other state or federal guidance. So here's what they're protecting against. It's 2021, it's the summer, we're all working on our plans this weekend. We implement the plan, 10 years go by, the CDC and New York State Department of Health put out some additional guidance relating to some future pandemic, and an employer says, but I put in place this plan in 2021, and that's what the law says. I don't have to follow the new guidance. This law specifically says you can't do that. So this plan is sort of a foundational aspect of having something in place if there is a future pandemic, but it's not going to relieve employers of staying up to date on whatever the Department of Health and CDC are stating. So talking about the actual plan now. So you have to establish a plan by August 5th, 2021. I'm sure that date is in everyone's head. One point of clarification on what Kristen said, let's say you establish one today. Technically, the law says 30 days from when you established it. So we're sort of assuming that everyone would establish it on the last possible day that you could. That would be August 5th. But if you establish it today, it's not August 5th today. So you would have 30 days from today's date. So that's just something to keep in mind in case you are ahead of the game and decide to implement the plan prior to the actual deadline. Plans must include exposure controls. We'll talk about that a little bit more on the next slide. It's got to consider industry-specific risks. So, whether you're working in office or retail or manufacturing, there are different risks associated with each industry, and those need to be accounted for. Again, it's the same thing like New York Forward when there's just industry-specific plans. There are just different risks associated with different jobs, and that's what needs to be in there. Big point here. So you're allowed to develop your own alternative plan. However, if you do, it needs to include meaningful participation of employees for all aspects of the plan if you're in a non-unionized environment. And if you're in a unionized environment, you need agreement with the unions. So the hint here is don't do that. I don't know what sense there would be in doing it, because what does meaningful participation from all employees and all aspects of the plan mean? I don't know, but I think if you went that route, there'd be a risk of not meeting that standard. And since the alternative plan would need to meet the bare minimum requirements of the standard plan, it just wouldn't seem like a good business decision to do that. But the option is available to you if you want to. The plan must be reviewed and updated whenever necessary. We'll talk about this a little bit later too, but it's sort of like, a Mad Libs. You fill in the blanks of this plan, and at the end it has a little spot that says, dates that were reviewed, by who, and sort of, it contemplates that it will be a living and breathing document that will change over time. So while we're adopting the plan on August 5th, 2021, it's unlikely that that will be the last version of your plan. It will probably be something that you'll want to look at, at a yearly or biannual date, just to make sure that you're complying with everything. Maybe your business has expanded, maybe you've sold off a part of your business, or maybe there's just some changed circumstances in the way your business operates. Those are the types of things that you'll want to make sure are included in an updated version of the plan. So those exposure controls that I mentioned earlier and that we said looks like New York Forward, it's the same things that we're all familiar with at this point. Health screenings, face coverings, physical distancing, hand hygiene, cleaning and disinfection, personal protective equipment. These are the things that all employers need to consider and that need to be present in the plan. There's a lot of overlap between all employers on what an employee or what an employer needs to do in regard to each of these, and there's guidance on those within the standard. But again, there are going to be industry-specific things that just aren't present in some places that will need to be present in other places. So I mentioned the fill in the blanks. These are the sections of the things that you need to fill in the actual plan. So if you haven't had a chance to look at it yet, it's on the New York State, New York Hero website, and you can download it. It's about 10 pages long, and it has like a fillable PDF basically where you can go through each of these sections. So the very first thing is, which employees are covered by which plan. This will not be the first time we mention this on the webisode, but you may have more than one plan. If you have employees that work in manufacturing, they're blue collar employees that are working on machinery, but you also have office space, they might be covered by different plans. So you might have a plan for one area of your business and a plan for another area of your business. And so the point being, when you're filling out your plan, you need to designate, this plan covers these specific employees. The name, title, location, and phone number of the supervisory employees that are designated contacts. So it's not just that you're going to have a plan in place. There are going to be people that are around to enforce it, and people that have their name associated with the plan. So that needs to be on there. And then it's going to have all the types of things we talked about, like physical distancing, engineering controls. Some of this is you don't have to do it. It doesn't say the word you shall do this. It says we may do this. And again, it might make sense for some employers to do some of these things and other employers to not do them. Those are things you're going to have to look at in your industry template and that you'll have to consider. But it's a lot of may, not shall in the standard and plan. So that's something to look at carefully when you're reviewing the draft. And then the last thing, as I mentioned earlier, the plan revision date. So who participated in it? What were the major changes? Who approved it? So they really want to make sure, they being the Department of Labor, Department of Health, that there's specific people that will be accountable for this plan and the enforcement of it. So what are those industry-specific templates? Here's a list of what they've released so far. We suspect that they really just wanted to go for the industries with, I guess, from two aspects. One, that have the highest population of employees in New York, and two, the ones that have the highest risk in New York. So that's something that I don't think will be etched in stone. I think in the future, what they're going to do is release more industry-specific templates. And if your industry is not on there, you'll want to make sure that you're thinking about what the specific things are associated with your plan. I think we've gone a few slides ahead. All right, I'm going to hand it back off to Krista now.
Thank you, Chris. So in light of everything Chris just reviewed, employers have some decisions to make relatively soon, by August 5th. And one is, are you going to adopt the model plan or create an alternative plan? Well, as Chris mentioned, there really seems to be no incentive to create an alternative plan because it does add the additional obligation of employee involvement in the decision making. So our recommendation is to utilize the model plan specific to your industry. And then, do you need one or more than one plan? How many work sites do you have? So for example, we have many clients, as Chris mentioned, in manufacturing. The plan for the workers in the manufacturing floor might be different than the plan for the office workers who work in headquarters. So those are the types of evaluations you need to make. How many locations do you have across the state? And do they perform different duties for your company? So those are factors you need to look at in determining which plan you're going to implement. What industries do you operate in? Do you operate in more than one industry? Some businesses are diversified and operate more than one industry. Certainly in those cases, you're going to want different plans that are appropriate to the industry that you're operating in. Who from management needs to be involved in making these decisions and finalizing the plan? Again, it depends. And the warehouse plan, probably, our manufacturing plan, the plant manager is going to be involved in that. We anticipate a lot of HR team members are going to be involved in these plans, depending on if the business has an HR team. One thing's for sure, you want someone involved that's, high enough in management to take responsibility for the plan, who understands, what's required of the plan, who's able to speak intelligently about it if there's questions. So you want to pick someone particularly carefully, as to whose name is going to be attached to this plan. With respect to the distribution of the plan, so it must be posted in a visible and prominent location within each work site other than a vehicle. So there's some ambiguity with respect to this in the way it's worded currently. It makes it sound like you might have to post it up now once you enact it. There's another theory that you would only need to post it when there's an actual emergency or pandemic going on that triggers the plan. From a best practices standpoint, we see no downside as to posting this once you have it finished. Certainly you can't be accused of not posting it by that point, but there's no downside. You just have to ensure that as you're doing annual updates and reviews that you're changing it out as required. Again, assuming that you adopt it today, as Chris mentioned, you'd have to distribute it within 30 days, and posting can be a part of that. You need to provide it to employees in English and in the language identified by each employee as their primary language of such employees within 30 days of adoption. So that includes Spanish and Hispanic employees. There is a template for that. We don't think you need to redo your handbook, although you do have to provide it in an employee handbook if one exists. So we're going to talk about this a little bit on further slides, but ultimately this policy should appear in your employee handbook along with your other policies. You want to be available upon request to all employees or bargaining unit representatives if you're a unionized workplace, the Department of Labor, independent contractors, and Department of Health. So the plan, if it's posted, that should make this requirement relatively easy to comply with. If you don't have it posted, it needs to be accessible somewhere and available to these agencies. And this is very much like the other requirements you have that you're already required to have posted with respect to labor and employment laws, discrimination statutes, and other compliance issues, MSDS sheets, and other OSHA requirements as well. One of the things we're talking about is that you can set a standalone policy, even if you are including it in the handbook. And at least if you don't want to redo your handbook for now, you can keep the standalone policy. Or post it on the internet if you're not doing a physical posting in your work site. The next component is a verbal review of the plan, verbal review in quotes as described in the guidance. So you definitely need to complete a verbal review of the plan when there's a designated outbreak. So again, as Chris mentioned, there's no currently designated outbreak. COVID-19 is not designated. This is another point of confusion, though, certainly with the regulations that have come out. The statute says you need to do a verbal review with the employees, and it sounds like you're supposed to do that when your plan is enacted and upon distribution, because it tells the employees that you're going to verbally review with them the existence of the plan, the location of where it's where it's housed, and how they can have access to it, as well as the circumstances under which it can be activated. So, do you need to conduct a verbal review upon the initial adoption and distribution of the plan? That's somewhat unclear at this point. But again, with most things, best practices and our recommendation, there's no downside to doing that. And it doesn't have to be an hour-long verbal review for sure, but something, relatively quick that informs employees of the plan and its location. The verbal review section is found under the training and information during a designated outbreak section of the model plan, which suggests it's only required during an outbreak. So again, it's up to you, boots and suspenders as to do it upon adoption. It also states, which is a little inconsistent, that employers will verbally inform all employees of the existence and location of the plan, the circumstances it can be activated, and the infectious disease standard and employer policies, which suggests a forward-thinking review. So also touches on methods, which is in person in a well-ventilated environment with appropriate face masks and personal protective equipment, or via audio or video conference technology. It looks to us like they're somewhat adopting, some interactive component with this, which makes sense. Somewhat that's been adopted with the harassment and discrimination training. But let's say you don't do the verbal component when you first adopt it, and when you're distributing it to employees, you'll definitely want to have it in place, because if there is a second wave of COVID, as people are surmising may occur this fall, you're going to want to have some type of verbal review with the employees. So, one thing that we're talking to clients about is, does it have to be physically in person? Can we do a Zoom video to review it? Can we do an audio or an audio message and record it and send it to employees via text message? There's not certainly that clarification necessarily in the guidance, but it seems to us that would satisfy the interactive component as well. Now, again, the outbreak of an airborne disease, what are your obligations? To review and update the plan. So as we mentioned, since there is no outbreak right now, but if one happens in 2 months or a year, you need to review and update your plan to make sure it's still current with your work sites and the industries you're operating in, as well as the composition of your workforce. You're going to want to finalize it and activate it. So that's a notification to your employees, along with the verbal review that you're actually activating the plan and its components, along with the requirements that will have to be followed now that the plan is in place. Again, you're providing each employee with a copy of it in English or the primary language. So here's kind of a nuance that they provided that we think is important to know. If you use the DOL template, you're not responsible for errors in translations. So if the DOL has made a mistake in translating the template, then it's on them. If you translate the template, it can be on you. So as you might expect, our recommendation is, again, to use the DOL translated templates, not to get fancy and translate your own, because that way you can rely on the DOL and there's no responsibility on the employer for that. You want to post a copy in a plan that's visible and prominent location at the work site, unless it's a vehicle. So again, a good spot are break rooms, places where you have your compliance posters, or house it also on your intranet site if you have one where you post your other policies. So once you activate it, you also need to ensure it's being followed. And what does that mean? That means you need to assign enforcement responsibilities, again, to a management team member to go around and make sure people are following the plan, using the PPE, engaging in the steps that are required as outlined in the plan itself. You want to monitor and maintain exposure controls. You want to regularly check information from the New York DOL, the CDC, et cetera, to see if there's any updates on the guidance while the plan is in place. Probably most of you are familiar with this. It's not too far long ago, we were in the throes of the pandemic where there was guidance and advice coming out almost daily from different agencies, and it quite frankly was very hard to keep up with. But if there is another outbreak, whether it's COVID or another disease, airborne disease, you're going to want to be on top of the updates, which the partnership does a great job in updating you, by the way. And again, finally, you want to designate one or more supervisory employees to enforce compliance. Again, I would anticipate it's the same person who has responsibility for the plan, and presumably that person's been educated and trained to recognize, what the elements are and to monitor enforcement and be in a position to get the resources from the employer that are needed. For example, if you're low on PPE or other things that are components of the plan, this person has the authority to step in and make the changes that are necessary to be in compliance. And then, of course, like with every other New York labor law, there's an anti-retaliation provision. So we are seeing cases now unrelated to HERO, but related to COVID, where employees are filing lawsuits against their employers saying that they complained about the employer not following New York State Department of Health or CDC guidelines, and that they blew the whistle on that, and now they're suing the employer because they were terminated after that. This statute does have an anti-retaliation provision, and it does say that an employer cannot retaliate, discriminate, threaten, or take adverse action against an employee who exercises rights under the standard plan or law, who reports the violations either internally or to a government agency, or who refuses to work where such employee reasonably believes in good faith that an unreasonable risk of exposure to an airborne disease due to the existence of working conditions inconsistent with the laws, rules, and policies. So that's a mouthful, that section. I think, we are going to see a lot of issues with that. We may start seeing them now, even though employees might mistakenly believe that we are in the throes of a pandemic or epidemic, and that this HERO Act is in place, and that they can complain about the plan. So it's going to be some definite legal issues associated with this, in my opinion, because when is it unreasonable to work? When is it a reasonable belief? These are all terms that are not necessarily defined and are heavily fact specific, in my experience, based upon the employer's circumstances, the employee's work methods, what specific situation is the employee complaining about, and does it relate to the plan or this law? They did add in that the employee must first give the employer an opportunity to cure, which is a great provision, because too often we see employees that don't notify their employers about an issue they have, and then they go straight to an agency and complain, which really doesn't help anybody, because in most instances, employers, are wanting to do the right thing. So if the employee just gave them the heads up, they might be, not be aware of what the issue is. The last provision is a record keeping requirement. And it says that employers must keep records relating to employer or employee communication about the risk for 2 years after the designation of the high risk disease from the Commissioner of Health. So, that creates another set of questions that seem uncertain. So let's say someone made a complaint, in September 2021 or May 2021. Do you have to keep that complaint for 2 years from 2021? Or, would you keep it until the pandemic's over? It seems to say that it's 2 years after the pandemic's over. So it's toning back the employee's right to file a civil suit, which is good news for employers, because there's certainly many opportunities for employees to exercise their rights and file claims against employers. But it seems the legislature did, the tenor of the statute is to comply with the guidance, and it gives the employers opportunity to cure it in the first instance. So it gives you the opportunity to cure. So our other piece of advice is, if you do get a complaint, cure it. If you're doing something wrong, certainly that will help stave off any liability. And with that, I'm going to turn it over to Chris because we're already receiving a lot of questions from our clients, and we thought we'd share, what we're at least telling them with you.
Thanks, Kristen. So one of the questions is, I was a super proactive employer and I created my own airborne infectious disease plan. So in our little hypothetical here, someone created their own infectious disease plan. We'll say it's in May 2021. So that's prior to the standard being released. It's prior to the template being released. It's prior to the requirement. What do I do? Do I have to create another one? Yes. I think the answer is yes. Even though that was great proactiveness on behalf of any employers that did that, no good deed goes unpunished in business in New York. And so your plan it's very unlikely that whatever the plan is meets the specific definitions and the minimum requirements of the plan template. And then from a second issue could be, unless you created meaningful participation from your employees, it's not going to meet that requirement too. So certainly you can probably repurpose whatever is in that plan to filling in the blanks in the template, or you could get that meaningful participation if it's a non-union environment, or get the agreement with the union if it's a unionized environment. But if those things haven't been done, that plan's not going to be sufficient to meet the New York HERO Act. Another question that we've talked about a little bit, my company recently distributed an updated employee handbook, but it does not include an airborne infectious disease policy. Do we need to redistribute a new version of the handbook that includes the policy? So the black letter of the law is, if you have a handbook, you need to have it in there. Some of you might be thinking, well, doesn't everyone have to have a handbook? Technically, no. There are parts of New York law that require policies to exist, like sexual harassment policy, or a policy that states vacation and sick time for employees if they exist, and things like that. But technically speaking, you don't need to have an employee handbook. It's just something that's highly recommended to make sure things are clear to an employee or to your employees. So if you don't have an employee handbook, you're in a different situation. But if you do have an employee handbook, and you just redistributed it, you probably think, I don't want to print them all out again, or I don't want to get the acknowledgments again. So one workaround that we see is distribute the plan to everyone as a standalone policy right now. Get their sign off on it that they received it, and then work it into your handbook and just use that for all new hires going forward. And that should be sufficient. And so down the line, your current employees will have signed off on a handbook that's not, doesn't have this HERO Act policy in it. But presumably you'll update your handbook at some point in time in the future, and your current employees now will get a copy of that handbook too. And so they'll eventually get it on the back end. But we don't see an absolute requirement that you change your handbook today for the current employees, especially if you just redid it. That might be burdensome, and that's one workaround we can see for that. What if my employer operates in more than one industry? We've said this a few times. It just worries me that someone's going to say, I work at, I'm a manufacturer, that's what I do, or I'm in retail, that's what I do. And while that makes sense on its face, the way that they've set this standard up and the way that they've set this template up, it's just very few people might actually fall into one particular industry. So they say it at several different points in the statute, they say it at several different points in the standard, and they say it at different points in the plans. You need to consider industry-specific things. We didn't go through in that much depth, the differences between the industry templates. To be honest, in large part, they're a lot the same. There are some specific things, but if you're looking at it and you're looking at page 1 and then page 2, you might say, wow, this looks like a little bit like the regular template. That's because it does, but there are some things in there that are different, and those things definitely need to be considered. So you might have one plan, but it's more likely or not that you have multiple plans. And for a really big company, you might have several plans. So it'll just depend. You'll want to make sure you think about that. But when you hear every employer needs to have, an airborne infectious disease plan, it's kind of a misquote because it's every employer needs to have an airborne infectious disease plan for every work site that they have that considers the industry that they're in. That's probably a better way to phrase it when you're thinking about what this requirement is. Another question, the standard states that we are supposed to follow New York State health guidelines or Centers for Disease Control guidance. What should we do if they differ? So if you're paying close attention during the last year and a half, the CDC said things and the New York State Department of Health said things. They didn't always, align. Sometimes the New York State Department of Health endorsed something entirely by the CDC. Sometimes they endorse part of it, but not all of it. But careful to keep in mind, mostly on the CDC website, on many of the pages relating to COVID-19 pandemic guidance, it specifically states that it is sort of the default guidance, but if there is something different from a locality that you operate in, you are to follow that locality's guidelines. So we ran into this a lot with clients during the pandemic, saying, well, the CDC says this, and it's a great starting point, but it's not the end point. New York State Department of Health had significant guidance throughout the pandemic, and even local counties had their own guidance at some point. So those localities were being deferred to by the CDC. And when we were reading over the statute and saw that, we thought, that's going to be something people have question marks on, given that they did differ at some points in time, and they will likely differ in the future if there is, a future pandemic. All right, so Kristen mentioned there's a checklist, so there's a lot of stuff on here we'll go through. August 5th, 2021. I think everyone's got it. We're not gonna lose track of that date. Did you provide the plan to your employees in writing? So again, 30 days from adoption. That could be the beginning of September, unless you've already done it. Then it'll be sooner than that. So keep track of that. That's your next deadline after you actually adopt the plan. Did you do a verbal review? Again, it's not entirely clear whether you need to do that in this initial instance, but it's probably going to be helpful, even if it's not required. This is because employees are likely to be confused. If you roll out this plan and they're going to think, there's still, people that are contracting COVID-19, and, even though it's going to say, there's no designation, whatever you write to them, someone's going to be confused by that. So the verbal review might be helpful in this first instance, just to explain to them, this is the plan if something happens down the line. You'll probably want to say that 10 different times to make sure that that's clear to employees, because inevitably there will be confusion on that. Did you post a plan to each work site? All right, so you've identified each of your work sites, you've adopted plans that associate with those work sites, and then again, another point that's a little bit unclear, but our best advice is just to go post it in the work sites, keep track of them for when you update the plan in the future, so that you can make sure that the most updated plan is in the work sites. But posting that plan probably in conjunction with the verbal review makes the most sense. And then, did you add the plan to your employee handbook? Again, our advice is not to do a standalone policy forever for everyone. It does specifically say it needs to be in the employee handbook. I don't know why it says it. It's formality. I don't know why it can't be a standalone policy, but that's what the statute says. So moving forward, that's what you'll want to do for new hires, but we do think it's fine to give a standalone policy to your current employees in this first instance. But don't forget about it actually says that in the law, so make sure it's added into the employee handbook in the future. Okay, so best practices. These are things that the law technically does not require, but we recommend. So the first is, did you obtain written acknowledgement from employees that they received the plan and participated in the verbal review? So, this happens all the time. An employer says, we have a sexual harassment policy. The employee signed off on it. We have training. The employee attended it. And the employee, files a claim with an agency and says they didn't receive the policy and they didn't go through the training. And the employer, the agency says, okay, employer, where's your evidence? If there's no written document, it didn't happen. So same thing here. The law requires that employees receive the plan. The law requires that there be a verbal review, at least at some point. Get a little, it can be a half sheet of paper that says, such and such employee acknowledge I received the plan on this date. I understood the plan. I knew who to ask questions of the plan. I went through the verbal review of the plan, and throw that in their personnel file, because if someone does make a complaint, that documentation is going to just start the investigation off on the right foot. So it's always good to have a nice paper trail evidencing when employers are complying with the law. Did you modify your onboarding process to account for the plan? So a lot of employers during onboarding talk about policies, talk about their employee handbook, or whatever else is going on for the new employee. So this is probably something to include in there. Again, it's not going to need to be an hour-long thing, but a few minutes of going over, hey, we have this plan, it's a part of the employee handbook, make sure you review it and you're familiar with it. If there is an airborne infectious disease designated by the Department of Health, this is what we're going to do, and this is how it applies to you on this work site. Those are things that, you know, are probably just a quick little tweak on your onboarding process. Did you train managers on the plan? Just like anything with our managers, we want to make sure they're educated on what's going on operationally. They're going to be asked questions about this from employees. Some of these people might be designated as, you know, with enforcing the plan. So we need to make sure the managers understand that. They understand the plan, they understand the responsibilities. That's something that, you know, again, not required by the law, but just is a good idea to make sure your managers know what's going on. Did you create a playbook for when, if an airborne infectious disease is designated in the future? So there are other requirements with the law that aren't necessarily super clear, super obvious when you're reviewing the standard or your template plan. But let's say an airborne infectious disease is designated tomorrow. Well, let's use a different example. Let's say it's designated on November 1st of 2021. You have 15 days to sort of, you know, update your plan, get it back out to employees, you know, do the verbal review. There are just things associated with that in the future. And just like a couple page document that we're calling a playbook that says, you know, if this were to happen, here's exactly what we need to do. And then sort of behind that would be the actual plan and the standard. But it just sort of says quickly, maybe bullet points, you know, this is what we need to do if this happens. So, you know, if something does happen, you can quickly go to that, pull it, read it quick and say like, okay, we don't have to scramble and see like, oh, when do we have to do this by? Oh, it's already in our little playbook. So that's something we recommend creating just so it's easier if you do have, if time goes by before the next one of these happens, it's not just sort of scrambling to think of, okay, well, we have this plan in place, but now what do we do with it? What do we have to do with it now? So that's something that we recommend too. So final note, regulations. So being an employer in New York, you're all very familiar with, you know, guidance, regulations from the Department of Labor. There's probably more coming, and they're not usually very fast with any of it. And so, you know, I was personally shocked that they got this out on July 6th of this year. I thought it would take more time. But they did get it out probably because they were able in large part to take part of it from the New York Forward materials, but there could be more coming. It's likely that there's more coming. And I don't think it was a coincidence, you know, when Governor Cuomo lifted the restrictions and they agreed to not have this stuff be in place for when a airborne infectious disease is not designated, probably took a little bit of the pressure off. So maybe we'll see something in a month, maybe we'll see something in 6 months, hard to say, but you know, what we've been talking about today is based on what we know so far. So keep a watchful eye for future regulations and future guidance. One other thing, if you go to the website, you can see, you know, they're accepting feedback from employers. So you can visit their website and you can talk to them about that. So that's always a good idea because, as Grant mentioned, they do listen sometimes and they change things. So there's certainly some things that can still be cleared up through guidance, and to the degree there's ambiguities, it's never a harmful thing to file a feedback, and they have that mechanism through the New York Hero Act website. All right, I think that's all for the content that we have. I think we'll kick it over to Grant to see if we have any questions.
Great. Kristen, Chris, thank you so much. And as I promised everybody, the presentation was so thorough. We don't have a ton of questions. We do have a few though, which we'll get to, and we'll help us close things right out at the hour mark as promised. If I could, though, I do want to just lean into one area briefly, if you'd indulge me. I think it's important for people to understand, and you guys highlighted it well, the liability piece here. Earlier versions of this proposal, as it was going through its various stages, had much wider liability exposure for employers. The initial iterations of this were actually very troubling. And so a lot of organizations, including the partnership, worked hard to strike a much better balance here. And so we ended up in a place that is certainly significantly improved from a liability standpoint than where we started. The point here is, though, I would just stress to those participating today that cure period did not originally exist. It is there now, it's important. And I'm certainly not an attorney, nor do I pretend to play one, but I would just encourage everyone to take that cure period seriously. And if something is brought to your attention by an employee, you do have that 30-day cure period to address it, and you should be smart about doing that. I don't know if the attorneys would like to sort of double down on that.
I agree with everything you're saying, Grant. If you don't comply within the cure period, you're just inviting a lawsuit and, you know, other potential investigation. I would also submit as a best practice, much like when you get complaints of harassment and discrimination, that you document, you know, what steps you took, how the cure was implemented, and that you maintain some record of that in case there is something that comes up down the line that you can definitively prove that you cured it within the time period. I don't know, Chris, if you have anything to add on that point.
Yeah, no, it's really helpful, Kristen, because the statute says, you know, they need to demonstrate an unwillingness to cure, and it can't stress it enough. And you've all probably heard it a million times, but on our end, we see it where it doesn't happen all the time. You got to have a document. And so a little report that says, you know, on this day, this employee, they complained, and here's the complaint, and this is what we did. And, you know, and this is the, you know, we followed this guidelines. And then if you do unfortunately receive a complaint from the employee moving forward, that's Exhibit A. And like, that's very powerful. But without that document, and it's, you know, yeah, we did it, but we didn't write it down, it's just so much harder to prove. And so that unwillingness to cure, that's what they wrote in the statute. And that document will show the willingness to cure, and it will deflate the claim. So that's, again, not something they haven't required that in the statute, but from a practical standpoint, that would be super, super helpful to do if you do receive those internal complaints from employees.
And in addition to the cure period, there are some other protections related to liability or the ability to recoup fees from a lawsuit that's deemed frivolous or what have you. So again, the message here is take the cure period seriously and then document the action you're taking, because only through doing that will you be able to protect yourself moving forward as those protections exist in the statute.
The other item I would throw in, Grant, is you may want to check with your insurance carriers now to see if these claims are covered by the existing insurance policies you have, whether you have general liability or, you know, not every employer has employment practices liability insurance, and those cover typical employment claims. So, you know, these will be relatively new claims. I would expect they're going to be covered by an EPLI policy, but it's something, you know, and I'm not an insurance salesman, but if it's something you may want to look at from a risk management standpoint, because, you know, people take for granted their general defense liability policies, which cover slip and falls, and if people get hurt, as well as workers' compensation. But for employment lawsuits, and they are increasing, and employees don't have to pay anything to file with any of the agencies or hire a lawyer, and employers are forced to defend them and hire attorneys. So it's definitely, from a risk management standpoint, checking with your insurance agent to see if you're adequately covered in the event you get claims under this as well.
Yeah. Okay, great. One of the questions I think we answered, but I'll just confirm the answer. It's around providing, do I need to provide a copy of the plan to my employees, and do they need to sign something, say they received it? I heard, yes, you must provide them a copy, and it's a best practice to have them sign something that stipulates that they've received it. Did I hear you guys correctly?
Yes, you did. The
Yes.
one ambiguity is that whether they need to provide it upon adoption, well, they do need to provide it within 30 days upon adoption, and what happens once it's activated, but you stated it correctly.
What if there is not a template for my industry?
I can take this. So I would start with the general template and then look at what you did last summer with New York Forward and look at those materials, and that's probably the starting point. And then I'd also try to identify if any of the industries, the templates that they have on there, while not your industry or like the closest to, look at the types of specific things in there that they're doing that were particular risks for them, to see if that might apply to you. You know, I think there might be more in the future. Don't wait for them. They're not, I mean, they made it clear you gotta start now. So do the best that you can. And then in the future, if they do have, you know, they release, you know, a template with your industry in November, I would look at your plan, and then you can sort of amend it if to the degree it needs to be amended. And then you'll say the reason we amended it is because you released the plan. And then, you know, you can do that. But don't wait for something specific to your industry if you don't exactly fit into one of those industry templates.
And we've inquired based on a couple of members who did not see themselves reflected in that industry breakdown. We inquired on their behalf of DOL about, should we expect additional templates? The general feedback to us was no, not at this time, but we know tomorrow could bring something different. So follow Chris's advice. Next question, what type of employee training is required? Is there a training model?
I'll let Chris, you want to take this one?
Yeah, there's no training model. It doesn't have a time requirement. It doesn't say anything like that. It just says verbal review, which is the first time I've ever heard that phrase was when I read the statute. I think it's as simple as you give them the plan and you just sort of walk through it, kind of like what we did here today. So you go through and say, look, here's the plan, you know, read it and we'll talk about it. Or maybe you can either give it to them ahead of time and then go through it, or you can go through it with them and then tell them to read it afterwards. But I don't see why this would have to be anything more than 15 minutes. And it was literally, and probably the part of the reason there's no actual template thing is because it might be different based on your industry. So maybe that was part of the reason they didn't do that. But that's what there does have to be this verbal review, and it can't just be an email. You know, it's got to be either in person or have some audio component, or be by Zoom or whatever application that you have. But I wouldn't stress about it too much. Just a short, 15-minute review of whatever your plan is, to say, hey, it exists. These are the circumstances when it could be implemented. You got to understand it. We'll go over it again if there actually is a designation, but we want to make sure you're aware of it. We take this stuff seriously, and that sort of general spiel, and you should be complying with this verbal review. And since it is required, we would, again, recommend that you get them to sign off that they participated in that they knew they could ask questions, that they had questions. Just it's always good to get that stuff in writing.
Great. We're at the hour, but we have two more, so we'll move real quickly. This is somewhat specific, and so if you guys don't feel comfortable answering, we could certainly get back to this person offline. But they say, we're a New Jersey-based staffing firm with no offices in New York. However, we have 100+ contracted employees working in New York client sites that we have no control over. Do we still need to adopt the plan?
I can take this one too. You got to look at the definition in the statute in 218B. It defines an employee and it defines a work site, and it has different, like staffing agencies count and contractors count, but only some of the requirements count towards you. So you'd want to look at that more specifically, but it does have a very broad definition of employees that are included. But you might not actually need to put together the plan for them because it might be the onus of that other employer. I don't think they wrote it super clearly, but they're trying to avoid the situation where you have a joint employer, two totally separate companies, and they don't want the companies to like point the finger at the other person and say, I thought this was your job to educate the employees on this. So it's in the statute that contemplated that, but we'd want to probably look more specifically at your particular company and the nature of your relationship with that, with the people you do business with, and where their work sites and how they're actually working to see whose onus it is. And you probably want to have a conversation with the people you're working with to say, this is our interpretation of the statute, what's your interpretation, and work collectively to make sure whoever's supposed to be the one that's actually putting together the plan and distributing it to those employees is doing it, and that it's not a scenario where the other company thought, you were doing it and you thought you were doing it. You thought the other company was doing it.
And it could be addressed in your staffing agreement too with the company, which is what we recommend for other compliance issues as well.
Great, helpful feedback. And finally, and I think it's a good point to end on, someone asked a question which basically says something like, wasn't there a requirement that we have to have a workplace safety committee? So we did touch upon that at the very beginning. Yes, the HERO Act does require employers to permit the creation of a workplace safety committee. Those do not go into effect. That portion of the HERO Act does not go into effect until November, and we are still waiting on the DOL to release the particular regulations as they pertain to that provision. And we would certainly follow up with people when we have that
information.
If I was a betting man, I would say we probably won't get it too far in advance of November, but I've been wrong before. Kristen, Chris, anything you want to add related to the committees?
I don't have anything to add at this time, Grant. Chris, do you?
Yeah, the only thing I'll add is the very important word that Grant used, which was permit. You have to permit them to form. If they don't ask, you don't, nothing happens. So don't talk about it. That's my advice. Unless someone comes to you and says, we want to form this committee, the law says you can't say no. But if no one asks, you don't have to come and say, hey, who's going to form the committee for the company? Don't do that. You don't need to, unless you voluntarily want to for some other reason. But it's a law that requires that you permit employees to do it. It's not a law that requires that you actually have a committee. So an important distinction there, and I'm sure there'll be more guidance out, on the day before it's effective.
Exactly. No, important distinction. And we've had a lot of questions about, we already have one, will this suffice? And the short answer, unfortunately, is we don't know. So we have to wait for the actual regulations to come down, and then we will certainly help people understand them to the best of our ability. It has been, I think, a very informative hour. I really want to thank Kristen and Chris and your colleagues at Goldberg Segalla for making this possible today, and for your ongoing support of the partnership, and for everyone participating. Thank you all so much, and have a great day.
Thank you, Grant. Our pleasure.
Bye-bye.
Thanks, everyone.
Bye-bye.